The October 17th, 2024 carryover hearing of the Arlington Board of Zoning Appeals is now in session. Good evening and welcome. I am Richard Kaplan, Chair of the Board of Zoning Appeals. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Inta Malice, Judy Freshman, Portia Clark, and Carol McCruskey. Also present are the professional staff, including Blake Bowen, Board of Zoning Appeals Coordinator, Brett Goldberg, BZA Associate Planner, Meg Ryan, BZA Associate Planner, online, and Brett Goldberg online as well. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss the board's power and the procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set forth in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance. Or the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or alleviate a hardship by granting a reasonable modification to a property improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent properties and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not of so general or reoccurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance. That the granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse or affirm wholly or in part, or may modify an order, requirement, decision, or determination appealed. The determination of the administrative officer or zoning administrator shall be presumed correct by the BZA. The appellant has the burden of proof to rebut that presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, laws, regulations in making its decision and must base our judgment on whether the administrative officer was correct. The concurring vote of a majority of the membership of the board shall be necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in person, on the front of the table, you will find a QR code linking to a copy of the application package, including the staff report for each of these cases before us tonight. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the applications packages. I recommend that if you have not yet seen that report for your case, you review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff they may have. Applicant or the representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the items will be called. Speakers must fill out a speaker slip online or is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit cross-examination or questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances. We have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Mr. Bowen's over there. I would like to seek unanimous consent from my colleagues to reorder the agenda and take the two EHO appeals first. Hearing no objection, Mr. Bowen, can you please call the two EHO appeals together?
Yes, Mr. Kaplan. The two EHO appeals are as follows. Case number V-11994-24-APP-1, appeal by Amanda and Luke Burke, Fred Redner, Sonia Lopez, Nina Hahn, and Kevin Meredith of the zoning administrator's decision to approve expanded housing option permit number ZEHO 23-00040 for a lot located in the R6 zoning district on the premises known as 5630 8th Street North, RPC 13038-008 within the Bluemont Civic Association. Staff recommends that the board adopt the, staff recommends that because Judge Schnell has ruled that all previously approved EHO permits are void, the matter is now moot and no further action by the BZA is necessary. Please note we do have supplemental material for this case. This includes an email from Tad Lunger requesting deferral, as well as a BZA comment form from Craig Deering, a neighbor to the northwest. The second EHO appeal, would you like me to announce as well?
Yeah.
Okay.
Yes, please.
That is case number V-11995-24-APP-1, an appeal by Abby Raphael and Michael Longe of the zoning administrator's decision to approve expanded housing option permit number ZEHO 24-00006 for a lot located in the R10 zoning district on the premises known as 3101 Military Road, RPC 04-007-015 within the Bellevue Forest Civic Association. Staff recommends once again that because Judge Schnell has ruled that all previously approved EHO permits are void, this matter is now moot and no further action by the BZA is necessary. Please note that we also have the same piece of supplemental material for this case, which is an email from Tad Lunger requesting deferral.
And I see we have a single speaker for both of these cases?
I believe that is correct, yes.
Okay, so I think that we are all here today to try and figure out what action we should take, and we're not here to decide these appeals on the merits. So I'm going to imagine that we probably don't need the 20 minutes per side, hopefully. I guess the parties should just state their name for the record, and then we'll hear from the county and then the two appellants.
Arlova Baum, zoning administrator.
Ann Golsky, representing the zoning administrator.
Thank you.
Microphone, or is this okay?
I think microphone for the, yeah. We have a number of attendees online, I see.
Right. My name is Tad Lunger. I'm here tonight on behalf of the appellants, Amanda and Luke Burke, their counsel with the Arlington Land Use Group.
Thank you.
And I'm Abby Raphael. I'm representing myself in the 3101 road matter.
Thank you. So typically we just hear from the county first, and then we will hear from the appellants.
Thank you, Mr. Chairman. I'm going to speak for the county, if that's
Great.
okay.
Thank you.
And basically, as we've said in our staff report, due to Judge Schell's ruling in the case of Norgren versus County Board of Arlington on September 27th, 2024, because the judge ruled that the EHO amendments to the zoning ordinance are void ab initio. The county administrator and the believes that the county must void all of the permits and that this proceeding is moot.
Thank you. Ms. Malice.
I have a short disclosure.
Oh, please, go ahead.
I'm acquainted with one of the applicants, Abby Raphael, but I have no problems with hearing the case objectively.
Thank you, Ms. Malice. I don't recall which appellant is first, so if one, we can hear from one. Sorry.
Okay, good evening, Chairman Kaplan and members of the Board of Zoning Appeals. Tonight, the BZA must consider, in my opinion, one of two alternative decisions. The first is to defer this appeal until such time as there is a final non-appealable order or judgment for the Norgren versus Arlington County case. Or the alternative, which is to expressly hold that the zoning administrator acted outside of her authority in approving this EHO permit as required by the circuit court holding in Norgren that occurred in this very same jurisdiction on September 27th. The Board of Zoning Appeals is bound by this holding and must apply it to the EHO permit and appeal at hand, and is required to find this EHO permit illegally issued. We look forward to discussing these alternatives in more detail in a few minutes.
Thank you. Ms.
Good
Raphael.
evening. Contrary to the staff recommendation to dismiss this as moot, in fact, the appeals are not moot, and we ask that you defer instead. So if the county board appeals the decision of the circuit court judge and is successful, the EHO permits would then be valid. They would no longer be void. And at that point, the builders could go forward. EHO permits, to my surprise, I learned in the FAQs on the county's website, never expire. They're valid forever. So if the appeal were to be successful, the developer could move forward, but I could not appeal because I have to appeal within 30 days of the approval of the permit. And so I would have no opportunity to appeal. There is case law on this. In fact, it was a U.S. Supreme Court case that came out of Virginia, Richmond Newspapers versus Virginia, and it talked about cases are not moot when they can evade review, when they can be repeated but evade review. And that's exactly what would happen here. The case could, I would want to bring the case again if the permits were then valid, but you wouldn't be able to review them. So for those reasons, we think they're not moot and would ask you to defer the case. If for some reason the county board chooses not to appeal, which I would be kind of surprised if that were the case, but then you could set it for a hearing at that point to dismiss the appeals for the reasons that Mr. Lunger described. Thank you.
Thank you. I guess I would like to hear if the county has a response to that before we hear from the speakers. If my colleagues.
And I'm happy to provide a response, which is we have no objection to a deferral.
Okay. Thank you. Mr. Deering. Is Mr. Deering in the room or online?
I am here.
Online.
Yes, I'm here. Do you hear me?
We can hear you, but try and speak up a little bit louder.
I apologize for that. I'm trying to get as close to the microphone as I can. Am I more clear?
Yes.
What would you like from me?
I'm sorry?
I'm trying to understand where we are in the process, so I need to know what you'd like from me.
Would you like to comment on these two appeals before us?
I'm hearing that the statement of the county is for deferral. Is that what we're commenting on now?
Yes.
Uh,
Or if you have any other comments that you would like to add in how this board should handle these cases tonight.
Well, my technical objections to the EHO permit, I think, are well documented in the staff report. They included the notes I submitted. I would say that those technical objections remain valid, but I don't know what action the BZA would be permitted to take on them if there's a deferral. So I leave that decision to the BZA. I assume you saw those in the staff report.
I'm sure that myself and my colleagues have read the staff report.
Okay. So there, I would wait for any further discussion, and if this matter is deferred until it comes back up in front of the board.
Thank you. Do my colleagues have questions for this speaker? Microphone.
Mr. Deering, are you speaking on the appeal at 5630 8th Street?
I am. I thought that was the first one on the agenda.
And what is your do you have a connection to this?
I live on the street.
Okay, great.
I live on the street, and I've been an active participant from the beginning in the missing middle EHO county process.
Thank you.
So it sounds like everyone is in agreement on a deferral. So I guess the question for us is how long of a deferral, and any details in that motion that would need to be addressed.
Does the applicant have a recommendation?
Would you like us to-
Yep. Do you have a recommendation?
Sure.
And then-
Yes. I mean, we suggested until there's a final non-appealable order. And we think that's right. We have no idea how long this process is going to take. And right now, since the permit is void, the permit holder really has nothing to do at this point. They can't start or anything. They're not harmed. That injunction has been ordered by the judge. And so they are stuck in this stasis just as we are. And that, even if this thing is if this permit is reinstated on appeal at the Court of Appeals, this very well could go to the Supreme Court, and we're looking at an unknown amount of time until this is resolved. And so we figured until there was a binding, non-appealable ruling or order that resolved this for everybody, we would just defer it until that time when it was worth the county's time and money and investment, as well as the plaintiffs.
Ms. McRusky.
Yeah. So I guess we have a circuit court order. We could have a Court of Appeals. We could have a Virginia Supreme Court order. I guess my question is simply, in the event, for instance, the Court of Appeals reversed what the circuit court did and reinstated that ordinance, would it then be important for us to be willing to take up the appeals? I'm just trying, and sorry, I don't have enough of a handle on appellate procedure at this moment, but it seems to me that it might be that wouldn't be a final unappealable. Well, it would be after 30 days. It would be a final unappealable order,
Yes, ma'am.
and then we could take it up.
Correct.
And I guess that would be adequate at any point, because if it's being appealed further beyond that, there's no action being taken by the developers. So, by permit holders. So I guess that will be adequate. Sorry. Took me going around the barn to.
No, it's good to
Mr.
talk about this out loud.
Ms. Nellis.
Can I just make sure I understand? If you were to lose at the first level of appeal,
Mhm.
That's what we're talking about right now.
Yes.
Would there be an opportunity for the developer to move forward in any way?
Well, what we were talking about is the order that, say, a Court of Appeals and feel free to speak up when I'm finished, but the order that the Court of Appeals entered doesn't become final unless it is in effect for 30 days and not appealed. So either in that 30-day period, nothing substantial is going to happen. And in the event no appeal is filed within the 30 days, then the deferral ends because there is a final unappealable order. So I think there's not going to be a time period that is sufficient for anything substantial to happen until there is a final unappealable order. And I think that's why using that language in our deferral motion would work.
Okay. And if there was that case that's unappealable in favor of the county, when would the BZA hear the appeal? At the next possible hearing, or how would that happen? I mean, I'm not
right.
You don't know.
I don't know. I would think that a judge who was entering such an order would have to, cover whether existing permits were in effect or not. And so if they were, then the appellants could come back to us and ask to be heard. Practicing attorneys can tell us.
And presumably, the stay that would be in place as a result of this appeal would still be in effect throughout the deferral until the case is heard by this board.
I don't think that's necessarily the case, that the stay would wait for our decision. If a court decided that the ordinance was valid, people would be able to move forward, but they wouldn't be, you're right.
In these two cases before us, there would still, right, because we're not dismissing it.
Right.
Can I make a comment? I think, as Mr. Lunger said, we don't need a date certain to defer this to. I too am not certainly expert in Virginia appellate practice, but I think if there were an appeal from the Court of Appeals to the Virginia Supreme Court, then, depending on what the ruling is and who's appealing, we just don't know. So there's kind of a lot of speculation with that. So perhaps what would make sense is to defer the matter until there is a final order in the Court of Appeals. We could come back before the BZA. We might ask again for a deferral if it could then be going up to the Supreme Court. We just don't know what the posture is going to be, but that would give us something more specific. And of course, it's in our interests if the EHO permits are valid, that we're surely going to want to get on your agenda to be able to be heard on the merits.
I guess I don't know if does the zoning administrator have any input at this point? You all want to?
We have we asked for recommendations from the parties. So if you have any recommendation as well.
I think it's okay if we want to hook this at the Court of Appeals and then reassess and see what's happening. What injunctions are going which way, and if appellate rights need to be exercised at that time. I mean, that's fine with us. If our co-applicant or appellant, she's recommending that, we're certainly fine with that. I understand the reasoning for that, and I don't think it would be a major logistics issue for this body to reassess for 10 minutes after a Court of Appeals holding.
Yeah, and the zoning administrator wouldn't have an objection to that.
Yeah, we could do that. I'm not sure it's necessary because I think at final unappealable, otherwise things are going to continue moving along pretty quickly. But I think we could do it to a specific time, and then we would have a marker set there, and that might be useful.
So it would be a deferral to the final order in the Court of Appeals.
Yes, ma'am.
Or
a final, if it
30 days after a final order.
Yeah, because a final unappealable order, because it could be one in the circuit court theoretically if people didn't appeal. So
that's right.
Is the language you're suggesting 30 days from the final order of the Court of Appeals in this matter? I think makes sense.
Yeah, so I will go ahead and try to frame a motion if we're ready. So I move that the Board of Zoning Appeals defer a decision in appeals number V1199424 APP1 and V1199524 APP1 until such time as either the time for appeal of the circuit court's order in Nordgren v. County has been, the time for that appeal has run, or 30 days after the date of any decision by the Virginia Court of Appeals.
I think that gets us there, except you said APP1 twice. So it's APP1 and
Oh,
APP2.
they both are APP1, but one is 11994 and the other is 11995. Those are the distinguishing numbers for the two cases.
Thank you.
I don't know if I'm permitted to interrupt, but this is Craig Deering. May I ask a question?
Can I clarify one thing first? It's been noted that it's Nordgren versus Arlington County Board is the correct party, so we'll put that in the motion.
Thank you. Do we have a second for that motion?
I'll second.
A motion for a deferral by Ms. McCroskey, seconded by Ms. Malice. Is there any further discussion? I have a,
May I ask a question?
please.
We're talking about 30 days from some action. Does that mean that this board hears the appeal at that time? Because we do have certain requirements like advertising and other things. I don't know what it is that actually is the 30 days.
I think that
What action or what,
I think
who does what?
I think for the next action this board would be taking would just be to bring the parties in and then work like more of a scheduling issue at that time, and then we would defer it for an actual hearing on the merits.
And
Okay.
I think we would set a hearing at the time that is the 30 days. So we wouldn't have to hold a hearing on that.
Our
exact
hearing.
date.
Like a scheduling hearing.
Yeah.
Like a scheduling
Well,
conference.
no, I think the point is we would need to set a hearing at that point.
Right. And then my question was, does that motion address the circumstance, the unlikely circumstance in which the county chooses not to appeal?
Yes, I believe that the first choice was that
I just
it's 30 days after the unappealed circuit
Okay.
court decision.
Great.
Say that.
Okay, any further discussion? I will,
Do we
Craig
feel
Deering?
language of the motion? Does somebody,
Let's ask the staff.
does the staff feel like they have the language of the motion?
I certainly wouldn't mind it being repeated.
Oh, great. Okay. I move that the Arlington County Board of Zoning Appeals defer hearings in the matters of V1199424 APP1 and V1199524 APP1 until there is a final unappealable decision of the circuit court in Nordgren versus Arlington County Board, or until 30 days after the 30 days after the Virginia Court of Appeals issues its decision in any appeal of that case. And at that time, the Board of Zoning Appeals would, at its next meeting, set a consideration of further proceedings on these appeals.
Thank you.
Just to clarify, I'm not going to say unappealable for the Court of Appeals because we were going to set it 30 days after that, no matter what, and perhaps re-defer if necessary. But even if it's not unappealed, 30 days after the circuit court, we're going to review. I think that's what we discussed, right?
Absolutely correct. Yes.
Ms. Malice, would you like to re-second?
I'm fine with the modification, the restatement.
Is there any further discussion? I will call the roll. Ms. McCroskey,
Aye.
Ms. Clark,
Aye.
Ms. Freshman, Ms. Malice. Chair votes aye. Motion for that deferral passes 5-0.
Thank you.
Both of these
Thank you
cases.
very much. We
Thanks for bearing
appreciate
with
it.
us on these new issues. Mr. Bowen, can you please call the first case on our agenda?
Yes, Mr. Kaplan. After I call this case, I will likely move back to my old spot, but I'll call it from here. The first case on the agenda that is not an appeal is case number V-11991-24-VA-1. This is a variance request by Zachary Williams on behalf of 2640 Shirlington LLC, the owner, to permit a left side setback of 1 foot to the ramp instead of 5 feet as required, regarding a ramp addition to an existing commercial building in the C2 zoning district on the premises known as 2640 Shirlington Road within the Green Valley Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the variance request with conditions. Please note that we do have supplemental material for this case that came in after the application packets were assembled. This includes a forwarded email from Yorandis Walder, the member of the Green Valley Civic Association, as well as a letter of support from Sharon Veladis, a neighbor to the south across Shirlington Road, who is located at 2659 South Shirlington Road. And we do not have at this time, to my knowledge, any speakers who have signed up to speak on this case.
Thank you, Mr. Bowen. Do any of my colleagues have to make a statement for this case?
Yes, I do.
Ms. Clark, please.
With regard to the variance for the ramp at the daycare center, case number V-11991-24-VA-1, I wish to publicly state that I am the president of the Green Valley Civic Association, which members have provided support for the variance application. I have not been engaged in their meetings with the applicant discussing this application. I am still able to participate in the debate and vote on the variance fairly, objectively, and in the public interest. I do not have any monetary interest in the Green Valley Civic Association or in the applicant's business.
Thank you, Ms. Clark. Do my colleagues have questions for staff on this variance?
I just have one question. And I was looking at the staff report and I didn't see this at the last minute, but is it correct that that the county board has placed a condition on the use permit that the applicant gets an approval from the Board of Zoning Appeals for this ramp before their use permit is final?
That is correct. More or less, I believe that is condition number 7 of the use permit approved by the county board in July 2024. It's for ramps and any other sort of encroachments that might merit consideration by the BZA.
Okay, thank you.
And to follow up on that, is this ramp, aside from it being a condition of the use permit, is the ramp, would it be a requirement if this were allowed, like a by right scenario, or is this like be nice to have or required to have under the building codes?
This would be and I'm not, of course, fully qualified to speak on the building code, but this would be a secondary ramp. There is already a ramp that is allowed under the building code for emergency egress. This would be more or less a secondary ramp in addition to a required ramp.
But the county board is requiring this ramp, or the county board is just because the applicant wants it, the county board's requiring us to approve it prior to the issuance of that use permit? That makes sense.
To my knowledge, this is a preferred ramp from the applicants for this and not a stipulation of the county board.
So if this board denies this variance, what would the recourse of this applicant be?
Sorry, could you repeat the question? If the BZA denies the ramp?
I guess before you state that, though, can I add that the use permit for the child care center has been approved?
Conditionally on our approval. Right, if this board denies the variance tonight, what happens to the county board use permit? And let's start with that. What happens to the county board use permit if this board denies the variance?
I would not say that I am qualified to speak on the validity of the county board use permit and if it would not be vested by virtue of the BZA's action. I'd be happy if we can perhaps share the condition language. There was a link in the staff report to the condition language specifically. It might take us a minute to grab that and pull that on screen, but that might be
Yeah,
worth
condition number
perusing.
7 speaks to this.
Yeah, it's on page 32 of the materials. And
Yeah,
maybe
and I remember
and
seeing it.
maybe we can hear from the applicant what their interpretation is, but we can read it as well.
And right, so I read condition number 7 to mean if necessary. So I guess I'm trying to figure out if it is it a must-have or nice to have? And perhaps the applicant is the person who could answer that question.
I will note that the applicant does have a PowerPoint presentation prepared to share with the BZA, so perhaps their testimony and commentary could shed some light on that issue as well.
Thank you.
So, but I mean, the plain reading of condition 7 says that they can't move forward until they get our permission.
It says if necessary. So I'm trying to determine if it is necessary.
But does that,
I think the if necessary was because there's a number of different things that the board, this includes that besides the ramp. I think it was sort of to cover, if they needed a canopy or if they needed something else that, they didn't enumerate it specifically. I read it to mean if necessary.
I think
let's hear from
the applicant can probably address
then,
my question, right?
But I think there is a question because maybe this permit isn't necessary to implement it, but.
Right,
anyway,
that's what I'm trying to get at.
Let's hear from the applicant. We can talk.
The applicant, please. Sorry.
Help us.
Mr. Williams.
I'll do my best here. Let me see if I can raise the podium a little bit. All right. Is now. Good evening. My name is Zach Williams. I'm a land use attorney with Venable representing ASYMC.
I'm sorry, but can you get close? These mics don't
we
pick up very well unless you get close. So raise it up and then you may have to bend down a little bit. Sorry.
Goes up and then it goes down.
Yeah.
There we go. Okay. Can you hear me now? Is that better?
A little better.
Okay.
A little bit.
Great.
Thank you.
Maybe a better.
This is a very short microphone.
Testing.
Is that better?
No.
No? That's not better?
I mean,
A little bit better?
a little bit. maybe.
Okay. I'll just speak loudly. So again, my name is Zach Williams. I'm a land use attorney with Venable, and I'm representing the applicant tonight, ASYMCA. And we have prepared a presentation, which you have before you here. Let's go to the next page, please. Before I get into the presentation, I'd like to give Charlie Williams with ASYMCA a chance to introduce the applicant and the child care project.
Thank you, Zach. Ladies and gentlemen, Armed Services YMCA is a military service organization that has been in existence since 1861. That makes us actually the oldest, longest serving military service organization in the country. We are an organization, a nonprofit, that works around the country around major military installations to provide programs and services to primarily junior enlisted members from each of the military branches and the Coast Guard. In this case, we are under a contract to provide childcare specifically to military families, and the site we have chosen in Shirlington in Arlington County is a third floor facility that will provide childcare for more than 200 children and will be in construction, as you've seen in the brief and in the application. I may jump to turn the microphone back to Zach, but we appreciate your consideration tonight.
Great, thank you. Let's go to the next slide, please. So as we've discussed, the county board approved a use permit for this child care center in July of 2024, and it included a condition, condition number 7, that speaks to this particular ramp. Our understanding of the condition is that the use permit is valid regardless of whether this ramp is approved tonight, but the condition, what the condition states is we can't build the ramp, which is shown on the use permit plans unless we get the variance. That's our understanding of the if necessary language in the use permit condition. Just to orient everyone, this is at 2640 Shirlington Road, which is just off of 395. It's in the Green Valley Civic Association jurisdiction. Next slide, please. It's a single tax parcel. It's currently occupied by a church, a 4-story church, 45 feet high, a Coptic Orthodox church. The land use plan designates the site for service commercial uses, and as we've already discussed, the county board did approve this use permit a couple months ago. Next slide, please. This is the proposed floor plan. These are actually the use permit approved plans that you're looking at right now, and you can see on the right side of the page the ramp. The ramp, which is shown on the plans, but it's in a bubble because it can't be built until, if and until the BZA approves a variance, and that's why we're here tonight. This is the area of the ramp where the ramp is proposed. As you can see, there's an existing stairwell, and just to beyond the stairwell, in that area there between the adjacent site and the stairwell, that's where the ramp would be if it's approved. The adjacent site is a commercial site. It's an ABC printing print shop, ABC imaging print shop, and there's a very large retaining wall, as you can see, that runs all along the site. The ramp would be under, the height of the ramp would be below that wall. That wall does not have any windows on it. It's just a completely blank face wall. I will note we have spoken to the owner of that shop, and he indicated support for this variance and no objections. Here's the civil plan showing just the technical variance plat, showing the ramp and where it's located vis-a-vis the property line. It would be between 1 and 2 feet off the line. There's a reason for that, is because we're not exactly sure how it will be built. We don't have the exact dimensions yet. We're still working on that. But that's the maximum, the closest it would be to the line would be 1 foot. And as I said, it would be right next to the stairwell. Next slide, please. So I want to walk through the variance standards. The primary purpose of this ramp is to provide emergency egress for young children and babies in cases of an emergency. Obviously, they are not able to walk. So the stairwell is not going to be very helpful for them, and they would be rolled down on a buggy on the ramp. That's the primary purpose of this. Next slide, please. So walking through the variance standards, there's a very unique condition to the property. It's got an extreme grade change of over 23 feet. The child care center is on the 3rd floor, but it's actually also at grade on both sides of the site. So it's kind of an interesting situation where, but can I have a little bit more time? Thank you.
Please continue.
Where even though it's on the 3rd level of the building, if you look at the building from the street level, it's at grade on each side of the building. And because of that, we need to get from the side of the building down to the grade. And the only way to do that is either with a stairwell or a ramp. The bottom 2 levels are actually the parking garage, which are above grade. If you look at the site from the front of the site, if you're at the rear of the site, they're below grade. So that's sort of the query that we have here, the uniqueness of this particular site. I will say this building is already built. It was built by the church, so it's already existing. So walking through the standards, the property interest had to have been required in good faith. The hardship cannot have been created by the applicant. Again, the property was acquired by the Orthodox Church, which built their church building on the site. It's all existing. It's pre-existing, and this applicant ever getting involved in this case. The next question is whether the variance will be of any substantial detriment to adjacent property. We showed the board exactly where that area would be. The adjacent property already has a blank face wall with no windows in that area. The adjacent property owner does not object to this ramp. It will have no impacts at all on the adjacent property. I'll also note we don't have any other objections from any other property owners in the record. Next slide, please. The next question is whether the condition or situation of the property is not of such a general recurring nature as to make it reasonably practical the formulation of a general regulation to be adopted as an amendment to the ordinance. So here again, this is a very unique situation. The significant grade change on the site is not typical or recurring or general in nature that would warrant a zoning amendment, a general zoning amendment here. Number 4, the granting the variance does not result in a use that is not otherwise permitted on such property. Already talked about that. The use has already been approved in a separate proceeding as a use permit. And then finally, the relief or remedy sought by the variance is not available through any other process. And we know that to be the case because the county board couldn't approve this. And that's why they have deferred it to the Board of Zoning Appeals to approve a variance for that ramp. We have done community outreach here. We've sent letters to all of the adjacent neighbors, every single adjacent property across Arlington Road, as well as on our side of the street. We met with the Green Valley Civic Association leadership, not including Ms. Clark, just want to make sure that's clear. And we also presented at the full body meeting of the Green Valley Civic Association just a week or so ago. And no objections were noted. There was general support for the variance. I already noted that the ABC Imaging location owner, who we spoke to multiple times as recently as today, again voiced no opposition to this variance. I think that's my last slide. We have our whole team here available for questions. We have our architect, our civil engineer, we have Charlie Williams with the applicant, we have our land use consultants, we have our whole team here. If there's any questions, we're available. Thank you.
Thank you. Ms. Freshman.
Yes, just a couple of questions. You talk about the topography, which is challenging. I presume this is primarily an emergency exit, so that you have a ramp on either side of the building, given how many children are anticipated to be there at any one time?
Yes, the use permit is approved for over 260 children,
Right.
all on one floor of the building. So it's a
Right.
pretty big building. It's a pretty wide building. And so ASYMCA has determined that, and maybe Charlie can speak to this too, that the one ramp on one side is just not sufficient if there's a serious emergency. To get all the children from one half of the building to the other half, they're not comfortable with it. They want to have 2 means of egress in case of an emergency.
Okay, and where are the children dropped off?
In the garage.
In the garage. So they go up via elevator?
Correct. Yes, exclusively within the garage. The pickup and drop off will occur inside the building.
Pickup and drop off is always a problem in any facility like this. But particularly with the grade changes, it's going to be a challenge, and the ramps won't be useful at all going up.
Well, the ramps are not for entering the building.
Right.
We've made that clear. The only way to enter the building with children is going to be through the garage. We actually have over 100 spaces available. So that was one of the reasons that this site was attractive, because it's got so much excess parking. And exclusively, it's going to occur through the garage. But these ramps are not going to be used for getting into the building.
So there isn't any access from the rear of the building on the upper, what would be ground level?
No.
25 feet up or something?
No.
I would certainly suggest gates at the bottom of the ramps, because other people will try to go up them. I mean, not necessarily parents and children, but they should only be able to come out.
It's a good point.
From the ramp. I've had some experience with this kind of a thing. So, but okay, so all of the pickup and drop off will be within the garage, which should help on some of the traffic issues, especially if the arrivals are staggered. Okay, thank you.
Anything from my colleagues? Ms. McCruskey.
So in this case, you may have said this in your presentation, Mr. Williams, and I apologize, but the hardship that you are identifying as unreasonably restricting the use of the property is what?
The grade change.
Okay. But and the grade change doesn't give rise, well, I guess it gives rise to the need for the ramp, but it's the setback requirement that is causing the need for a variance.
That's right, but because of the grade, that's how we need the ramp to get out of the building, which is, if you think about it, it's at grade, yet from street level, it's like 20 feet above the street. So it's the first floor of the building. There's parking. It's a parking garage underneath if you're looking at it from the street. But on each side of the building where the doors are, that's grade. We actually have a playground on one side that was approved by the county board, right outside the door. So that's the very unique, sort of unique situation that we have. That's the hardship that we have in this case.
So also, so to have the ordinance of general regulation that could fix this is reducing the setbacks. Would that not fix your problem?
Or another exemption, right? So the ramp on the left side already has an exemption under the ordinance. So adding another exemption under the ordinance would fix that too for ramps.
Which is not necessary because the vast majority of properties are not going to have this problem. Are not going to have this problem. This is a very unique feature that we don't need to go into the zoning ordinance to do a general amendment because the vast majority of properties will never have this problem.
They don't have the grade
Correct.
problem, which is your hardship.
That's
you're
correct.
saying.
But
okay, go ahead.
I'm sorry, I was going to say, but any daycare of this size on the second floor would have this problem, right? So I'm not sure I'm there for the grade quite yet, right? So any you know, my view of the hardship is one is the size of the building, right? Because it's a big building. So we're
okay.
You know, the argument is it's a big building, so we need a second ramp, right? We're on, you know, the grade change on the property, but that could also be solved by an ordinance regarding a second floor, right? Because this is really a second or a third floor issue. And then the third point is that my initial view of the hardship is that it's the decision to make this building a daycare that's bringing the hardship, that's bringing the problem here.
I don't think this would necessarily be unique to a daycare. I could imagine a number of uses that might need emergency egress. I don't want to speculate, but you could have other types of care or other types of facilities where I don't know, doggy daycare. I'm thinking outside the box here. Memory care,
I think
senior
that's
living.
McCroskey's point about it could be solved by a zoning ordinance amendment.
It seems that the building is inappropriate for the use. If you're arguing, so if you're arguing that there could be other care requirements, then it seems like there ought to be a building code that says for this amount of floor space for memory care or child care, you need, you know, so many points of egress, which I think you've complied with as far as the building code goes, right?
I believe so, yes. The
so
building
you are
code
in
is
compliance with the building code as far as egress goes. Your desire for a second one is based on a judgment that your client has that a second one would be nice or better.
it's a safety concern, and maybe it might be worth hearing from Charlie.
That's what I was trying to get at before we heard from the applicant is you know nice to have or must have, right? If this board,
it's the building code,
right? If this board were to deny this variance, then it sounds like the applicant would have to go back to the county board and try and get the use permit without it.
Well, and I actually, and I know you were going to get your client to come tell us, and that's great. But I think then after that, let's get to the question of, does the county board's condition require them to get this approval for the use permit or not? Because I do think that is still in question. But let's finish out the first question.
But if I might comment on, it's my understanding that this condition number 7 is if any changes were made after the approval was done. I mean, the building is built, it's been approved, it's been through all of what needs to be vetted. This is an added option, but any other changes or conditions is what the board was saying needed to be presented as a variance or come forward, not just for this ramp. This ramp was not specified just that. It's any conditions or changes. So it's not contingent on it. If they don't build the ramp, it's for the safety of the kids. That wouldn't be met.
And I guess, right, that's the question, right? That's what we're trying to figure out.
So, right. So since we're getting into this, I think part of the issue is if you look at the condition the condition says that it's anything shown on the drawings. And as Mr. Williams pointed out, the drawings show a bubble around this additional ramp. And they say this is an potential additional ramp. It doesn't necessarily, so I think there's some gray area as to whether this particular ramp, the first ramp is there, it's already shown, but this ramp is, I think it's not very clear whether that is something that was required since it's in a bubble on the drawings, which is generally a change.
I guess so what I would ask is, was that ramp shown on the original approval for the childcare? Because I thought this was added for the variance specifically. That ramp didn't show on the original drawings.
We have the original drawings in our set of materials and it's shown, but it has a bubble and it says potential additional ramp. So it's sort of vague as to whether that was actually included or just an option.
And I think it's also worth pointing out that this board typically wouldn't accept a bubble with, we're going to put a ramp in here and we're not sure what the dimensions are for a normal, homeowner applicant here. And, so we probably have to talk about that concern as well.
Oh,
Ms. Malice?
yeah, I get a little confused that the floor plan you showed, is it reversed or something in our package? Because the bubble shows on the right side. And I think you mean it to be left facing, right?
Mr. Goldberg, can you bring up that floor plan?
It is on the right side.
The third floor plan. I'm a little confused on this drawing. Maybe it's just been backwards.
That's the variance plat.
Yeah, that's the right side.
Page 30.
If you go a slide back, I think you see the floor plan. Maybe not.
There's a floor plan in our report.
Right. But the floor plan that went, I don't know which one you want, but there's one that went
Slide
to the
6.
county board.
Slide 6.
And that's page 36 of 41. And that's the one that shows the bubble. And I think it's showing it on the left side of the
But
building.
this looks like it's on the right side. That's why I'm confused.
If you're facing the building, it's the right.
So is this
Okay,
just
so is that
On the
page
east
3?
side.
facing the building?
If you're facing the building, it's on the right side.
So we're looking towards the street in this floor plan?
We're like looking overhead.
We're looking overhead.
Yes, we're looking overhead
And what side is the street on, Mr. Williams?
in the front.
Ah.
So in the front of the
It's the
site.
bottom.
Or the bottom.
Oh, the street's at the
Okay.
top.
No,
No, it's at the
No.
bottom.
at the bottom.
But I thought the one on the right is the one that already exists. But that's the one that's bubbled and says potential.
The one, okay, if we're looking at the building, there's the ramp on the left isn't built yet. That was approved by the county board.
So
The ramp on the right is going to be the same exact thing as the one on the left.
The advertisement language
it
says
says left side
left side
setback.
setback of 1 foot, but it looks like we're looking at the right side
No,
setback.
it's the, I mean, if you're looking at this, if you're in the building looking at the road, it's on the left side.
So the road is at the top.
No, the road's at
I
the
think-
bottom.
I think that
Okay.
I think our variance language should say
Right and left doesn't matter. It's east.
What might help is which ramp, the one that's on the left of this drawing or the right of this drawing, which one is the variance sought for?
The right.
One on the right, okay.
And so the staff report.
Is the one with the bubbles.
The staff report, which has been posted online and advertised, says
Says-
left.
It's that they're asking for a left setback.
Another issue.
That's why
I don't know, does
it's
it
not
read?
just me, right?
No, I saw that too.
I'm very confused.
So does someone want to speak to those slew of issues?
Maybe the architect.
Yeah. With, I guess we're trying to figure out what the county board approved, and what it is the county board's approval of this project based upon our approval. And if we deny it, then what happens next?
Okay, my understanding of the condition is that if the BZA denied the variance, the use permit is still valid, but the ramp that you see in that bubble can't be built. That's the only thing that can't happen. That's my understanding of the condition. I'm not the county attorney. It's a legal question in the sense, but I did draft that condition with the county, and that was the purpose of what we were trying to do, so that we wouldn't have to go back.
So your view is then what you're asking for is nice to have, optional, not a requirement of this use permit.
It's not a requirement of the use permit.
But no. You want it.
Correct.
Yes.
That's correct. And I guess there was a couple other questions. Whether it's a requirement or not is not the variance standard. I mean, when folks come to the BZA, anything they're asking for is something they want. And that's the case here. The purpose is that in order for the programming of this child care center to operate in the safest, best way that ASMYCA thinks it should operate, it needs the 2 ramps.
Which also is not a standard before us. Right.
That's the
Virginia variance standard does not include safety requirements.
I would say that I am I may be getting to a conclusion that there's a hardship based on the grade, because without that grade, the ramp would not be required. And that not having the ramp creates an unsafe situation, which could be an unreasonable restriction on the use of this property. And I'm not saying I've made my final decision, but I'm kind of, I look at this as important, and I'm kind of thinking that maybe that's where our standard is met for a variance. And I think that, I think we're all concerned about if this is necessary for your use permit to be valid, and I take it you don't think it is, but I think that's one concern that we have, because, we want to know what the effects of our decision based on our standard would be. So that's why we're all concerned about that.
Mr. Chairman?
Ms. Malice.
I'm having a little trouble understanding how the grade is an issue, since this is on an upper floor and they're looking for some kind of egress from an upper floor. That would be necessary regardless of the grade.
And that goes back to my initial thinking of the hardship here is being brought by the applicant by having this specific plan for this specific building.
So anything on the 2nd or 3rd floor, if they need to bring carriages down, it's going to require a ramp, even if there was no grade change. But I do, the issue of the floor plate is an interesting question, because that perhaps, the building wasn't built with that use in mind.
Right.
Otherwise, it would have been 3 feet narrower, and then they could fit it in, or whatever the footage was.
May I respond to that as well? Because I think it is an interesting question. It's the 3rd floor of the building, but for all intents and purposes, it's the 1st. The first 2 floors are parking because of the way the building is built into a hillside. So the first 2 floors are a parking garage. And you'd say, well, is it underground or below ground? It depends on what part of the site you're looking at it from. If you're at the highest point of the site, it's underground. Mm-hmm. If you're at the lowest part of the site, it's above ground. Mm-hmm. But for the first occupiable floor in this building is the 3rd floor. And that is an exceptionally unique condition, and you don't see typically.
I mean, if you hadn't built anything below grade, it'd still be above, it'd still be 2 floors up.
I suppose that you could, but then you need to figure out where to put the parking. So you have to park the use. It's a church.
No, you could have 2 floors of parking above grade, and then your first floor usable floor space is above the 2 floors of parking.
And that's sort of what this is.
But yeah, because of the grade here, the parking is partly underground, but you still need to get up to the third level to be at the first habitable space. That's not parking garage. And I am still thinking through this, but I'm
Yeah.
trying to understand that's where the grade affects it, is that if you didn't have that grade, the parking would all be underground, and the third level,
Or
the
it could
first
be all
level,
above ground. I mean, that's
it could be, right.
the first 2 floors of the building.
The reason it's not is because of the grade on this one, because you would require going a lot further underground.
And
I wonder if we could hear from the architect on this left-right thing and how these drawings are oriented?
yeah, and I was just gonna say, I'm kind of overlooking the first hardship phase, but we're required to make the finding that this property was acquired in good faith and the hardship wasn't created by the applicant. And my like overriding view here is that it's the applicant's choice to use this in this facility in this way, which is creating the hardship. Can the architect address those concerns?
Yes.
Where is the?
Right, and then, right, because it looks like the summary of the action required has the left side setback, which we're asking for. But it looks like it really should be the right side setback.
It's in the staff report.
Can you please repeat that? Sorry.
Mr. Goldberg, can you bring up the first page of the staff report? So what has been posted on the website for public comment and review has the request, the owner to permit a left side setback of 1 foot to the ramp instead of 5 feet as required, but it appears from everything we've seen that it should be on the right, not the left.
We're very confused.
Yeah, it is on the right side of the site. If you're
It's
looking
on the right, if you're in the building looking at the
Right, but,
street.
That's how you measure.
Right, but on
right
the
facing.
advertisement language is left, right?
That's
Oh,
correct.
right.
That's
Right,
right.
so my point is that the language that has been posted for public consumption has it incorrect.
Or if we're talking about the ramp being built where the building is here and the ramp is built here, then it's to the left side of the ramp that's attached to the building, or is it talking about the other properties left side?
Yeah, I think it depends on how you're looking at the site. If you're sitting in front of the site, looking outside, it will be there.
If you're facing the building.
But if you're looking dead on, typically how you
It'd
look
be
at
on the right.
sites.
Which is right, exactly.
Yeah.
That's exactly right. Yeah,
The advertisement is not correct,
the advertisement's not correct. Right.
and we can't act on it.
But if it's defining a left side setback from the other building, is that not correct? Because the ramp's going to be on the other side.
The setback is from the YMCA building, not from the ABC building,
Setback from, okay.
because it's the setbacks from the property line of the property we're talking about.
Then it's to the left of the property line.
But it's referring to the right side setback, though.
On the ABC
They
side.
they want to move 1 foot within the right side of the property. And this says left side.
Does
Mr. Kaplan, if I may, I just want
does
to,
staff have an opinion here?
I just want to say that the Code of Virginia does not require descriptive summaries to be published in a newspaper, so I don't think there's an advertising error here. If the BZA is inclined to act on this request, they could just amend the language of the resolution to say right instead of left. We are no longer bound by the advertisement language that is published because we no longer have to publish a descriptive summary.
I guess that's an issue of fairness for us to decide if we're willing to do that. Which I don't know.
So when people do a QR code, they read the summary, right?
In terms of, our staff report, does also mention that it's the eastern side of the building. So I can see that there could be some confusion here. I understand that, I would probably call this a right side setback myself. Perhaps, other people would call it a left side setback, depending on how they're looking at a plan.
Anybody I've been on the BZA that would call this a right side setback or a left side setback when it's on the right.
Yeah, my point ultimately is though that you are not
Stop that.
ultimately bound by the advertisement language since we only published a very general description, a variance request being sought at this address.
Let me just say, we have provided notice. We've talked to all of these neighbors, in particular the one on the side setback where this variance would be, and we have his consent. So there's been notice that's been given. There's been extra notice that's been given. The Green Valley Civic Association held a public hearing that we presented at. We met with the Green Valley Civic Association leadership. We've gone above and beyond in terms of community outreach and notifying the public, and there is not one single note of opposition in the record. There's no speakers here tonight. In fact, you only have letters of support in the record. And so I don't think, we need to get hung up on left, right. I wish they just said east, because that's what we said to avoid this issue.
Not the way we do it.
But,
Sorry.
we said east because it's clear what east is.
Well, I was actually a little confused about the east-west too, because it really is facing east.
The setback, the setback is the eastern setback, the east side of the building. So we also have a variance plat that we submitted that shows exactly where the setback is and where the ramp would be. That's also in the staff report. And the resolution, as I recall, I believe references the plat, which shows where the variance would be.
Yeah, I mean, I think that issue, I think we understand that issue.
But I do think if I could let Mr. Williams discuss the need for the ramp, because I think it's important to hear
that,
from
yes, that we have not addressed
from ASYMCA on this.
I think we got sidetracked there.
Thank you very much. So first of all, if I may, this is a facility that will be fully licensed in the state of Virginia and in Arlington County. It's going to be nationally accredited by NAEYC, the NAEYC, for providing childcare. The quality and standards that we need to meet are all in line. The nature of the requirement for the ramp, it's two widely different things to say. I think you use the words nice to have or requirement. I wouldn't call it a nice to have. I would call it a safety second safety measure in addition to the one ramp that has already been approved by the conditional use permit by Arlington County. The concern we have an alternate means of egressing something like 80 to 85 children between the ages of 0 and 2 who are not going to walk down the stairs. We have another means. If we lose the use of the one ramp that has been approved, we would prefer, for clear safety reasons, to be able to use a second ramp in case of an emergency. If the one ramp is not available, that we would be then able to egress those 0 to 2-year-old kids and any staff who are not mobile down that second ramp instead of the alternate means that we have. So while not strictly required per se, I don't consider it a nice to have. I consider it an additional safety measure that will be very important in the operation of the facility.
Thank you. Anything further?
Motion.
Ms. Freshman?
Somebody give me a motion. I'm going to make it. I move the Board of Zoning Appeals approve the attached proposed resolution use permit case. I thought it was a variance. No?
Yeah, it is.
Is it not a variance?
It's variance.
It's a variance.
Yeah.
Okay. Begin again. I move the Board of Zoning Appeals adopt the attached proposed resolution granting variance V-11991-24-VA-1
Is there a second?
Second.
A motion by Ms. Freshman and a seconded by Ms. McCroskey for passage as advertised. Is there any further discussion?
Yes.
Ms. Malice?
The applicant indicated that the exact nature of the ramp has not yet been developed. And that's why it's in a bubble. And yet the resolutions refer to all the drawings, and they would have to be built in accordance with the drawings that are in the staff report. Is the applicant prepared to do that?
Mr. Chairman, I would like to also say the first whereas has to say right side setback.
So why don't we take Ms. Malice's and then we could entertain a motion to amend, motion to change.
Thank you. The variance plat does not have the bubble. The bubble was on the floor plans. The variance plat, which is the plat, would be approved as part of this
What page is
case. It shows a dimension
What
from
page are
1
you-
to 2 feet.
I'm
That
sorry.
was page on the staff report. I'm not sure which page it was. In my presentation, I think it was page 8.
18.
I assume this motion has our standard form language that basically locks you into what is on your plat.
Correct.
Not just 1 to 2 feet, but actually the layout that is on your plat. That's typically what this board would approve.
That's the purpose of the plat. This is a survey.
Because earlier you indicated that you don't have a design yet for the
Right.
stairwell, but
We
now
don't know the
which one is
exact
it?
dimension. We know it's between 1 and 2 feet. That's what the variance plat shows. But this is not the variance plat. This is a survey.
So
But what
document are you want us to rely on?
That's it.
the footprint shown on the survey and the architectural drawing. So which one is the plan that we're approving?
This one. This is the variance plat. This is it.
And that's page 18 in our staff report? Is that
It's 19.
at 19?
It's 19.
19.
All right, so the exhibits with the bubble are not operative. So I think we could refer to plat. I'm sure it's got a date here, right?
9/23.
They're part of the submission for the variance.
It's part in the staff report.
Yeah.
There's at least 3 different drawings that depict a ramp in the staff report, right? So the condition language is shall be constructed in accordance with the footprint shown on the survey, the architectural drawing attached to the staff report. And it seems like they're perhaps different. One's in a bubble saying optional and one is not. I don't know if that matters.
Right. The bubble one, I think, is more of a floor plan, right?
I guess my question then is for staff, is this the plat that you would rely on?
Depending on how you condition it, yes. If this is the survey plat, or excuse me, this is the variance plat that the applicants would like us to rely on as the for their measurements, as we had done for developing and reviewing the case.
It's page 19 in the staff report.
Correct.
I don't think it's harmful to call that out in the resolution, because we've had cases where there were multiple plats and the courts got involved trying to figure out what we meant.
Mhm.
And we need to, as Ms. Freshman reminded us, we need to alter, change left to right as well. So if someone wants to work on that.
So this. So this page 19 document is called the 9/23/24 BZA plat.
And maybe we reference the fact that it's prepared by Bowman Consulting Group because that makes the engineering drawing specifically.
So we would be amending the first paragraph, the first whereas, to permit a right side setback of 1 foot to the ramp. And we would be amending the first resolve to refer to the architectural drawings in the report dated October 11, 1924, specifically the 9/23/24 BZA plat prepared by Bowen Consulting. I guess I'm asking unanimous consent.
Any objection? No objection.
And now we can speak to the motion.
So,
Now, yeah.
so
and I
right, a motion
second
by Ms. Freshman, seconded by Ms. McCroskey, and amended by Ms. Malice. Would anyone like to speak to the motion? I will call the roll. Ms. McCroskey,
Aye.
Ms. Clark,
Aye.
Ms. Freshman, Ms. Malice. Chair votes no. Motion passes 4-1. Do we want to take up the minutes next? I haven't read them either. So
I haven't, why don't
we will not act on the minutes. We'll
throw
take
them
care of that
next time?
until November. And so the agenda now having been fully completed between yesterday and today, this hearing is adjourned.